Important decision there from the Constitutional Court. For more reaction on that court judgment, we're now joined on the line by its spokesperson for Parliament, Mr. Moloto Mothapo. Thank you very much indeed for joining us this evening. Can we get your initial thoughts and reaction to the Constitutional Court's ruling today?
Yes, indeed. No, thank you, Mr. Andoro, and to the viewers. Parliament indeed has noted the outcome of the Constitutional Court, and we respect, we accept the judgment, and will ensure that it is fully implemented. You remember that Parliament, the National Assembly, through its Rules Subcommittee, had already initiated a process of overhauling the rules of the National Assembly. That process started in 2012, and earlier this year, the National Assembly adopted the overhaul of about or just over 90% of the new rules of the National Assembly. So the issue of how do you codify Section 89 of the Constitution into the rules of the Assembly to ensure that an appropriate mechanism or procedure is established to implement that important constitutional provision is a matter that was amongst the provisions or the new rules that was pending. And we are confident that with this particular judgment, we will be able then to finalize, receive the inputs that have been outstanding from political parties so that we can finalize that amendment of the rules.
All right, so from your understanding, the rules need to be put into place. Will those rules be used again for President Jacob Zuma, or is this for future?
Well, once you amend the rules or you overhaul, because the overhaul of the rules itself, remember that it has not been done at this large scale since 1994. So it was important exercise that Parliament undertook to ensure that the rules of the Assembly are firmly consistent with the Constitution of the Republic, as well as many other legislations that govern the operation of Parliament. So this particular directive by the Constitutional Court, as it has already been underway within the corridors of Parliament itself, will then be realized through the existing process that has been ongoing.
All right. Earlier today, when you issued your statement, you said that the Speaker certainly wasn't found wanting in this decision, and this is the relief that the applicants had sought.
Yes, you'll remember that the relief that was sought by the applicants was that were primarily two. Number one, that the Speaker of the National Assembly be declared to have failed in her duty to hold the President accountable. The ConCourt did not grant such a declaration. Secondly, the relief that was sought by the applicant was that the Speaker should be ordered by the court to immediately establish an impeachment committee to probe the conduct of the President with regard to the Nkandla matter. That relief was not granted. Instead, the justices of the court found the National Assembly in its entirety, collectively, to have failed in its duty to meaningfully exercise Section 89 of the Constitution. So, if you look at the relief that was sought by the applicant, and you compare that with the judgment, you'll see that it has not been granted.
All right. So, as a citizen at home watching this, I'm probably thinking, hang on, what's the role of the Speaker then? Because it's from the judgment, Parliament has failed the people. Is the Speaker not in some way duty-bound to correct Parliament when it errs?
Well, the Speaker, its role is very politically neutral. That's why the Speaker would not even participate in some of the votes that take place. In terms of the existing rules, the motion or whatever resolution or a proposed resolution that comes before the House, it is done through the members of Parliament that represent the political parties. It is not done by the Speaker of the National Assembly. So the Speaker, because of her political impartiality or neutrality, cannot, by her own volition, initiate a process for the removal of the president, which is itself a political process. So the Speaker would not have acted in that manner, because in having acted that way, as requested by the political parties or the applicants, it would have been unconstitutional.
But can she not say anything if she sees that the House is not doing its job properly? Does she just sit and watch and just say, you know, order?
I think if you look at the judgment of the Constitutional Court and the very fact that there has been certain remedial action that has been sought by the applicants, and yet the judgment itself does not say anything in reference to the Speaker, you will see that the court itself appreciates the submission that the Speaker made, that there is a process already underway of Parliament exercising its duty in terms of the overhaul or the amendment of the rules in order to adequately give Section 89 of the Constitution proper expression in the rules of the Assembly. So that's why the judgment itself is phrased in a manner that it is phrased, because I believe that it is in recognition of the process that is underway that has been undertaken by the National Assembly. So there is an appreciation that there is something that the Parliament has been doing in order to give meaningful expression in the rules of the Assembly, that particular constitutional provision.
All right, so every time that there's a court judgment against Parliament, what it means is that Parliament has failed the people. As a citizen, what must I be thinking if the people that are supposed to be representing me are not doing their job? What do we do?
Well, I think we have to accept that in a constitutional democracy such as ours, Peter, it provides for a system of checks and balances. It essentially means that Parliament will not always be able to fully or be capacitated to fully interpret the Constitution. And it therefore requires will from time to time look into the Constitutional Court for a direction as to how to interpret certain provisions of the Constitution. So when there are certain judgments that are given, clarifying certain provisions of the Constitution to Parliament, it should not be seen as a bad thing or a tragedy, as you put it, but it should be appreciated as an exercise and a function in motion of our system of separation of powers as well as checks and balances. But having said that, we do agree with Chief Justice Mogoeng in the minority judgment, concurring with the Deputy Chief Justice, that the judiciary should be wary to interfere, not to unnecessarily interfere in the internal business of the legislature, because it is provided in the Constitution that Parliament has got the powers to determine its own rules, practices, and procedures.
All right.
So it is not advisable for always to approach the court and to force them in a very uncomfortable terrain of having to give such a directive to the legislature.
All right, we'll speak about the separation of powers just now, but just getting back to this idea that Parliament has failed to do its job, it was the minority parties that actually went to court. If, when you're all sitting in this assembly, if someone puts forward an argument that is sound, it should be sound, right? Why do they have to take the majority party to court to get a ruling that backs them? So what I'm trying to suggest here is that maybe the challenge that Parliament has is that a majority party can sometimes act deliberately beyond the rules, beyond the law, for whatever reason, and you end up having to go to court to try and correct that.
Well, I wouldn't throw the majority party into this particular judgment or into this particular case, because there is nowhere where the majority party is being mentioned. But it is a case that was brought against the Speaker of the National Assembly by various political parties. So I wouldn't want to unfairly throw the majority party into the mix of things. But having said that, the previous judgment of the Constitutional Court in particular, where they have dealt with the matter involving Parliament or the conduct of Parliament, the judgment have often said that political parties in Parliament should resolve the issues politically without involving the court. And in this particular case, as we are saying, there were many options that the applicants could have taken advantage of internally without going to court. Of course, appreciating that they have got such constitutional right to approach the court is a right that they enjoy. But Parliament does provide for various provisions for dispute resolution internally without the involvement of the court. In this particular case, for instance, we are saying that there is a process that has been ongoing even before this case took place. And it is a matter that there is already a sort of a draft with regard to how do we codify Section 89 of the Constitution into the rules of the National Assembly. And what was required was that the political parties in Parliament were supposed to provide the committee, the Rules Committee of the National Assembly, with their input as to how this matter can be articulated in the rules of the National Assembly. So that is one of the issues or provisions in the Parliament that the political parties could have taken advantage of. Right. But also, as and when these kind of things happen, there are various forums that can be utilized in order to discuss these things. And when there is only at a time when there is no resolution to whatever dispute, then political parties can seek external relief.
All right, Mr. Mothapo, I think what I'm trying to get at is, let's forget about the current setup, who's president, who's the ruling party, whatever. In the future, the danger is, the way things are set up, whatever the majority party is, whoever it is, can always outvote minority parties over issues, all the way down to subcommittees. And as a result, if they choose to be delinquent, who's there to stop them?
Well, I'm not sure, Peter, which specific example you want to use, because...
I don't want to use an example. I'm just wanting to focus on the idea that if you have a majority in Parliament, if you choose to do things that are not correct, you will always outvote the voices of reason.
Well, it is in the nature of our constitutional democracy that matters have to be decided first by persuasion, superior argument, and if there is no argument, because the decision at the end of the day has to be taken, the matter has to be subjected to a vote. That happens, Peter, in every constitutional democracy all over the world. So whether the issue it's irrational or not, That's the reason why we have got a system of checks and balances, so that those who are not satisfied with the manner in which the process unfolded can be able to seek relief elsewhere. But the emphasis, as I have already indicated, is that as much as possible, there should be an attempt, and that is what the previous judgment of the Constitutional Court has said. There must be an attempt to discuss and to resolve issues politically, internally, without the involvement of the court.
All right, so Mr. Moloto Mothapo, we're going to leave it there. Thank you very, very much indeed for sharing your thoughts with us this evening and giving us the Parliament's insight on today's ruling. Thank you very much indeed.